the items on our agenda. Now we'll move on to item number 2, Senate Bill number 355, an act concerning limitations on the use of non-disclosure agreements. Is there a motion?
So, second.
And this will be JF to the floor. Any comments or questions? Senator Sampson.
Thank you very much, Madam Chairman. This is a bill that we've had before the committee a couple of times before, and in fact, it's also been before the Government Administration and Elections Committee in the past. And I've always opposed it, not because I disagree with the stated purpose of this bill, which is that we're trying to protect victims of effectively criminal behavior in some cases, sexual assault, etc. Obviously, we would like to do that. My concern about this legislation as proposed is that every time I see it, it always has the same, what I think is a very important and very significant flaw, which is that it denies the right of the victim to make their own decision. There are a number of other concerns with the language of the bill, and certainly things worth discussing. So maybe I'll cover some of those. But while we're talking, I want folks who are listening to remember that for me, this policy works very well up until you reach the key ingredient, which is we're denying the right of that employee to make their own decision about what's best for them. And in my view, that is something that we should not tamper with. The victim, if we want to use that term in this particular case, they should be able to decide whether or not they want the behavior to become public, whether they are exposed as a victim or otherwise, or they prefer to keep the option open of entering into a non-disclosure agreement. I think that the reason why not NDAs exist in those cases is very often because the victim doesn't want the notoriety or the public attention of what occurred. And certainly if it works to their ability to receive compensation where they might not in a case where there's a criminal prosecution, they might choose that as an option. And I can understand people that think that that's a bad policy or bad precedent because it allows people that engage in bad behavior to go without prosecution. And I think that's a viable argument to make, and I don't want to dismiss it. But I don't think that outweighs the ability of the victim in those cases to be able to make their own choices. So I just want to clarify a few things. There are some other issues that even if I agreed with the policy as is, I would just caution against. The first thing I would ask about is current existing employment contracts that include NDAs or NDAs that are entered into separately from their employment contracts that are pre-existing today. Does this policy language that's before us retroactively void those contracts, Madam Chairman?
Thank you, Senator Sampson, for that question. I know that I want to find the right reference to that, but I do believe there is a reference to existing agreements. Yeah.
It's right here, 383.
Right.
You got it.
So under this proposed legislation, if an agreement was entered into prior to October 1st, it shall be void and unenforceable only where such provisions was entered at the outset of employment or during the course of employment. For a prohibited non-disclosure, non-disparagement provision, void and unenforceable under this subsection, the only recoverable damages would be relating to the enforcement of the provision. The provisions of this subsection shall not apply to any agreement that was contained in an agreement to settle a claim. I think that's your question, correct?
Yes, ma'am. Although it generates a couple of other questions, but the short answer is yes. This language has the potential of voiding existing agreements. But I do appreciate there is some additional language that is, I'm guessing, intended to protect things that may have been agreed to in the past. So I'm just trying to understand the rest of this paragraph. If there was a situation that occurred and the parties entered into an NDA and maybe the employee received some sort of compensation, and this does not have to be a criminal item. This could be just any activity that they felt that they did not want to make public. Does that mean that the amount that the employee received as compensation for signing an NDA, and I suppose it could work the other way. I think an employer could also receive compensation from an employee under the, might be odd circumstances, but I think it could happen where, one of the parties offers the other party compensation in exchange for a non-disclosure agreement. Does that mean that the contract's void even though money changed hands, which mean there'd be no repercussions for violating the NDA if this bill passes? Through you, Madam Chairman.
I'm not sure I 100% understand your question because it was a long one. So maybe you could summarize and give me the question again.
Sure, and I'm sorry. I kind of
That's
got caught in thought while I'm developing the question. But I guess the short question is, if there was a prior agreement between the parties to sign an NDA in exchange for compensation, does this bill void that contract despite the fact that money might have already changed hands? In other words, could they keep the money and still break the agreement through you?
I believe this would allow for that, yes.
Yeah, thank you very much, Madam Chairman. That's concerning to me. We've got people who are outside of this building going on with their lives as free citizens, we hope, although I question that as we continue to make more and more policy that deviates from the notion that they're free adults able to conduct commerce on their own. This committee seems to think with the extensive amount of legislation that interferes in private contracts that people are not capable of conducting those agreements themselves. And this is another one. I want to understand the compelling state interests, which is a requirement in our laws that when we make legislation, we have to have a compelling state interest for why we're doing it. What is the compelling state interest with voiding an agreement that was entered into by parties voluntarily where one side was compensated? Through you, Madam Chairman.
I think it's in the public interest that even in those cases, the prohibition on disclosing the behavior and the things that happened to that person in the workplace, that prohibition, it's against the public good. If, in fact, as you stated in your opening, that you share a concern, that it allows that behavior to continue perhaps to another individual.
Well, thank you very much, Madam Chairman. And I understand what you're saying, except that this doesn't necessarily apply to something that is criminal in nature or sexual abuse or anything like that. This applies to other things, too. There could be other embarrassing activity, perhaps. Maybe someone's behavior at a party. Maybe that's the employer's behavior, and the employer's willing to pay the employee, or maybe it was the employee's behavior that they want to protect and ask the employer upon departure not to disclose. That doesn't sound like something that might happen in most people's day jobs, but I know that one of the main proponents of this legislation is a former employee of a large news organization. So they're effectively a celebrity themselves. And in situations like that, I think that people like that certainly have lawyers to review their agreements and so forth. They don't enter into anything without having a full understanding of exactly what's happening. But this effectively could say that an employee couldn't, if they paid an employer to not disclose their behavior in some way that might embarrass them, especially in a situation like that where you have an employer and a celebrity employee part on difficult circumstances, if you're going to void the agreement, even though the money's already changed hands in exchange for that silence, you're opening the door for people just to share all of these secrets that were paid for. And I would just like to make a distinction that this is not just criminal or really abhorrent behavior like sexual assault. It does include other items. Is that correct through you?
Thank you for that question. It does include other items, but those items are all a matter of violations of law. None of them are frivolous. So the items that are covered, it prevents, it voids an agreement if it restricts the person from discussing discrimination, harassment, retaliation, wage and hour violations, sexual assault, or other conduct that violates public policy.
Thank you very much, Madam Chairman. So are you suggesting that the lines contained in that paragraph that begins on line 383, I guess it's subparagraph F, where it simply states any agreement that was entered into prior to October 1st, 2026 shall be void. And it says at the bottom of the paragraph, provision shall not apply to any non-disclosure or non-disparagement provision contained in agreement to settle a legal claim. Are you suggesting that this paragraph is also subject to the terms that are contained elsewhere in the bill that say that the only unenforceable agreements have to do with criminal behavior?
Hold on, I want to make sure with LCO that we get you the right answer.
No. No.
Thank you. Thank you for allowing me that moment to make sure. It is often hard to make sure we know everything that's related back to. But if you look at lines 333, that's where it describes what becomes a prohibited agreement. And then when you go to the line you questioned in 383, the final line on starting on 390, it says the provisions of this subsection shall not apply to any non-disclosure. Oh, no, that's not the right line. Oh, I know. It's the first line, 383, a prohibited non-disclosure. So by saying a prohibited non-disclosure or non-disparagement provision, it references back to the description of what is prohibited.
I appreciate that, Madam Chairman, except for the fact that you have written this bill in a way that does not define criminal behavior as legally impermissible. What you have done is you have written this bill to allow the employee to decide what's legally permissible. If you go to lines 333 to 352, it says that any provision in agreement between an employer and employee or volunteer to disclose or to discuss conduct that the employee or volunteer reasonably believes, this is the operative term that's in this bill and it's used several times, It's what that employee or volunteer reasonably believes under state, federal, or common law to be legally impermissible, and then it describes those items. But what is defined as an unenforceable or void contract on line 340 and 341, where it says shall be void and unenforceable, that points back to what the employee reasonably believes. So why are we giving the employee the ability to determine what is legally permissible? Through you.
The language that describes what a person reasonably believes is a standard that is used throughout our legal system, and it's well understood by lawyers and by judges. If an employee an employee will have to prove if, in fact, they were to disclose something that happened in violation of their agreement, they would have to be able to prove that they had good reason to believe that the activity was described as no longer permissible. And so I think that an employee who takes that action is maybe going to have to prove that it was reasonably believed. And I think the words reasonably believed are accepted language in most courts in an interpretation of law.
Thank you very much for the answer, Madam Chairman. I know that reasonably believes appears throughout many of our legal statutes, and that's understandable since the legal profession permeates the legislative membership, and they have a very powerful lobby. And this particular bill is a litigator's dream. This is an opportunity to make all kinds of money and fight over what reasonably believes means in court. That's why we often don't see bills that are written in clear language. It's all designed to make sure that this ends up in a courtroom where a bunch of lawyers can make a lot of money arguing over what someone reasonably believes. And that's really sad, because now we're talking about the fate of individuals that are trying to conduct business, whether or not they are subject to defamation by having their words misused against them or their behavior described in nefarious ways. And as I pointed out, Madam Chairman, my larger concern is that you've put all of the focus and legitimacy in the hands of the employee. And I don't understand why. I described a set of circumstances where the employee might be the one going to the employer looking for an NDA because they don't want their behavior to be exposed, and they're willing to pay off the employer for that purpose in a non-criminal situation, but maybe an embarrassing one. But we've left it up not to the employer to determine whether things are eligible to be void, and therefore keep the money and run and still expose that employee or not. I think it's a very poorly conceived way to do this. That entire paragraph is all wrapped up in what the employee reasonably believes, instead of an objective standard that any reasonable person on the outside would say. I think that that's the way it ought to be written if we were trying to be responsible. We would say behavior that a reasonable person would believe is legally impermissible. That would make much more sense. I'm just throwing that out there as a recommendation if this bill moves forward, that let's be a little more careful about who we are allowing to make the subjective determinations.
Can I respond to that? Thank you. I think that what we're trying to get at here is to make sure that an employee who separates and has signed a non-disparagement agreement or a non-disclosure agreement, if they determine that if something terrible happened or something just violation, maybe it wasn't the abhorrent behavior that we've heard expressed, but maybe it was a violation of law that they were not, that they would have the ability to move forward and disclose that. Now, if there's a better way to write this that allows that freedom or gives that permission to that employee to violate that agreement, bring a case forward, if there's a better way to write it, I don't think we're opposed to that. So, this may be one area where we could find a better phrasing of that, as long as we're not changing the ability of the employee to pursue other remedies. And hold on, this is a little weird because I know we're going back and forth, but I see that Representative Hughes would like to enter into this discussion. So with your permission, I will allow
Madam Chair, thank you, Madam Chair. I just wanted to weigh in on a couple of things and that my good colleague does bring up.
Representative Hughes, as long as it's pertaining directly to what he just said, I'd like to prevent a back and forth that's disorganized. But if you're speaking directly that will help answer the question he raised, I'm fine with that.
Just to clarify, a lot of these NDAs are prospective and expected upon, contingent upon the employment, or at least expected, right?
I don't think we're at that point yet, but you can raise that when we get through with Senator Sampson's comments. But he's right now been directing his comments to agreements that were done on separation. Am I correct?
That's correct.
So let's stick to that for the moment.
I'll save my couple of comments to weigh in on this conversation, but I like it.
Okay, fine. Go ahead, Senator Sampson.
Thank you very much.
I know that was a little risky, but I thought
Yeah, no, look, I'm open to the conversation. Look, I wish we had more of this, to be frank with you. I think there's not enough actual debate going on in our committee meetings where we can actually come up with real live concerns and maybe unintended consequences, and we can head them off by crafting better language in a bill proposal. I'm extremely sympathetic to the people that came before us, and over the last several years, it's not been a good feeling for me to vote against this legislation. I want to support people that are coming to us looking for help, but I also have grave concerns about overstepping. And certainly the area where I think we're overstepping more than anything is in the case of where you have the employee actually wants to engage in the NDA. And I think that this ultimately prohibits that because it doesn't allow them to enter into an agreement, even if they choose to, depending on the extent of the behavior. And I really just think that choice belongs to them no matter what. And I get that some people might have a different view because they want to make sure that we are prosecuting bad behavior, and I get that too. But for me, that is the tightrope. That's the struggle. Is what's more important.
Can I respond to that?
Sure.
I believe that we may have a very different understanding of what the intention of this language is, because I believe that this would allow a person who enters into an NDA to keep that. It would not. They would still have the ability to prevent not the disclosure, that it's initiated by the employee, so they wouldn't have to initiate that activity that would void the agreement. And if that's not clear, again, I think that's something we can clarify. But I don't disagree with you where an individual enters into a non-disclosure agreement and wants to continue to make sure that what occurred is not made public, that is still within the control of the person who entered the agreement, the employee. Go ahead.
Thank you very much. Madam Chairman, the bill respectfully doesn't read that way. It defines what a prohibited NDA is in the bill. It doesn't leave any choice or opportunity for either the employer or the employee to decide. It describes what a prohibited non-disclosure or non-disparagement agreement is, as you pointed out a little while ago. And I think that's what the whole bill is. I mean, right now, NDAs exist because employers and employees enter into them of their own free will. And that happens at the start of employment or an after separation agreement. Those only happen because the parties want them to, which is, for me, why I don't understand why this is before us, because we're effectively taking what happens in the real world by nature. I had this exact same conversation in the Housing Committee the other day. Things happen in nature for a reason. There's a reason why lease agreements have an expiration date. It's because when people meet up and they work on the terms of their arrangement, that's part of the conversation. Same thing with an employee-employee arrangement. Like, okay, well, how much is my pay? When do I get paid? What are the benefits? That's what people work out on their own. They don't need us making laws to cover those things. That's what free people do of their own accord when they're entering into business relationships. And we should be careful when we're taking away the freedom of those parties to decide what those terms are. And I get the fact that the majority feels that there are certain places where the government has a role to step in. I would agree that there are some places, when it comes to the safety of minors, for example, we shouldn't be putting kids in coal mines, et cetera, and we should have protections for that. But I'm a little more loath, I think, to say you should not enter into a voluntary agreement of your own choosing, like this bill says. The fact is that people who are in the middle of some element of turmoil at the separation of employment have to make choices sometimes, and they may be difficult choices. But ultimately, at the end of the day, they're their choices. They can either report criminal behavior to a police department or some other authorities. They have the power to do that now. And people sometimes choose to do that. Sometimes the employer will suggest that there's an alternative. Sometimes the employee will suggest that there's an alternative. Taking away those opportunities from the parties to come up with what they think is the best solution, to me, is the problem. Now, I mean, there is a subject of coercion, which I also have another concern about. I would not want to see an employer coerce an employee into signing an NDA. That's a different thing altogether. I have no problem working on legislation to prevent that in particular. I'm more concerned about the case where the employee really wants the thing. They're the ones that want the NDA, either because they're the ones that actually have something to lose because it was their behavior that would be protected, or because they simply would much rather get a check than be dragged through the press or some other situation that they don't feel gives them the proper justification, or it's not going to make the situation better. What happened, and having it publicly known doesn't make it better. Retroactively voiding contracts in this bill, I'm just going to kind of sum up just so we can get to that. But I have an amendment I want to offer that I think might help us get to a better place. I don't know if you will agree, but we will try that in a moment. Because the bill goes pretty far in some areas, retroactively voiding contracts, as we just described, I think it undermines certainty for a lot of businesses. There are some very large corporations out there that have thousands of employees. They may have God knows how many non-disclosure agreements that are out in the world, and if you write a policy that voids those contracts, that's a lot of uncertainty for a business, and it's an exposure, which I don't know is a smart thing to do. Again, we're trying to make Connecticut a more attractive place to operate and do business, sending a message to the business community that if you come to Connecticut and move your large corporation here, that the legislature might just on a, random Thursday in March decide that the contracts that you've entered into for the last 25 years don't matter anymore. I think that's really like a scary message to send to business and industry. And ultimately, I'll just wrap up by saying the employee choice is the major concern. A worker might prefer a private settlement. They might prefer compensation. They might prefer confidentiality. The bill eliminates those things. So, Madam Chairman, I do have an amendment. I think that there's been copies handed to the clerk. Can we hand them out maybe, or does everybody have them? Okay. So I would like to move adoption of an amendment, and it's very straightforward. It's a single. It's done twice because of the two parts of the bill, but it's very, very straightforward. This is notwithstanding language. It says, notwithstanding the provisions of the section preceding it on line 316, any prospective current or former employee or independent contractor maintains the right to enter into an agreement containing a non-disclosure or non-disparagement provision at the discretion of such prospective current or former employee or independent contractor. All it does is it says everything else in the bill can stay, but the employee doesn't lose their choice. If they want it, they can have it. And the same thing after line 399, just to be conforming with the rest of it, does the same exact language, more or less. It's a little shorter version, but it says, notwithstanding the provisions of the section, any employer or volunteer maintains the right to enter an agreement containing a non-disclosure or non-disparagement provision at the discretion of such employee or volunteer. I move adoption, and I'd like a roll call vote.
Thank you. We'll take a moment to review the language, so we'll go on pause. We're going to recess this meeting for 10 minutes so we can closure agreements that are illegal. They are prohibited. They are voided. If they...
Yes. Representative Gauthier?
No.
Representative Mastro Francesco?
Yes.
Representative Shake?
No.
Thank you, Madam Chair.
Thank you. Back, moving on. Are there any other comments or questions? Senator Sampson.
Thank you very much, Madam Chairman. I appreciate the desire to continue this conversation and to work on the bill. I thought the amendment couldn't be more clear, frankly. I thought it was interesting that you mentioned the...
Sorry. Excuse me one moment. LCO does point out on amendments we have to call Okay, we're back on the record. I don't know if that was 10 minutes because I didn't pay attention, but we're back on the record. And thank you, Senator Sampson, for giving us a moment to look at your proposed amendment. I looked at it and I do think that there is some room for agreement here on the fact that we think an employee should be able to enter into a non-disclosure agreement and shouldn't be prohibited from doing that. However, we also believe that there's nothing that you cannot restrict a person through any kind of agreement for contracting away their legal rights or something that is illegal activity that has happened. They still have the right to pursue that, to remedy it through the courts. They can't sign away their rights. I think this is, I think that we're not that far apart in our agreement if we're concerned about an employee having the ability to enter into a non-disclosure act, but we do want to be clear in the law that there are non-disclosure agreements that are illegal. They are prohibited. They are voided if they cover up illegal activity. So we're going to vote no today on this amendment, but I think we can continue talking about it. Maybe we can find a way to construct language that we ultimately could agree on.
Unless you want me to say something else.
You don't need to. With that, I will ask the clerk to call the roll.
A roll call vote has been requested on Amendment A to Senate Bill 355. Senator Kushner?
No.
Representative Sanchez?
No.
Senator Cabrera? Representative Wilson?
No.
Senator Sampson?
Sampson is yes.
Representative Weir?
Yes.
Representative Hall? Representative Hughes?
No.
Senator Lesser? Representative Canino?
Yes.
Representative Gauthier?
No.
Representative Mastro Francesco?
Yes.
Representative Shake?
No.
Thank you, Madam Chair.
Thank you. Back, moving on. Are there any other comments or questions? Senator Sampson.
Thank you very much, Madam Chairman. I appreciate the desire to continue this conversation and to work on the bill. I thought the amendment couldn't be more clear, frankly. I thought it was interesting that you mentioned the...
Sorry. Excuse me one moment. LCO does point out on amendments we have to call the roll and then announce the tally and close the vote on amendments. So, Mr. Clerk, will you announce the tally?
The tally is as follows: 4 votes yea, 6 votes nay.
Thank you, Mr. Clerk. Proceed.
Thank you very much, Madam Chairman. As I was saying, I appreciate the comments that you made about desiring to work on this bill going forward, and I will take you at your word for that. I just am compelled as a member of the minority who works very, very hard to try and make sure that we are knowledgeable about the bills that are before us, that we are reading through them in great detail, that we are understanding what is happening, that we don't offer an amendment like that casually. It's a desire to fix the policy. I tried to make it as narrow and clear as possible, and I'm disappointed to see what I think it failed on a party line. You mentioned the idea of people giving up their rights. I'm fighting for the same thing. The amendment says that failed says that the employee maintains the right to enter into an agreement. That's what the amendment was. I'm the one fighting for the right of the employee in this particular case. People sign agreements and give up their rights all the time, actually, but that's okay if they do it voluntarily. You know, when you take a job and you say I'm going to go to work 9 to 5 Monday through Friday, well, guess what? You give up your right to stay home and watch The View. You know, you don't get to do that anymore. You've got to go to work. People make choices about what matters to them, and sometimes people will give up their right in exchange for something else, compensation. And having a right and exercising it are not the same thing. People are not necessarily giving up their rights when they give up their desire to exercise them in exchange for compensation. I want to preserve their right to enter into this agreement if they choose.
Can I
Sure.
respond briefly? And we don't usually have this kind of dialogue, but I think that there are some things that you've said this morning that we both take each other on our word. And when you say that you are concerned about coercion and you don't want to see coercive behavior where someone is coerced into signing an agreement, I think that's what gives me pause with your amendment. Will it open up an opportunity for more coercion? Having said that, I've been very clear that if there is a way to come to an agreement on an amendment that clarifies that a person can enter into a non-disclosure act agreement, then we can pursue that. I just think we need to take a little more time to make sure that we're careful in the drafting. I am not suggesting that you weren't careful in it, but I think we need to be careful in what we understand it to mean. I do think there is a conflict here, though, as well, that we're trying to get around. First of all, we know that someone can't right away in any kind of agreement their right to pursue a claim in court for a violation of the law. So a non-disparagement agreement or a non-disclosure agreement, you can't, neither party can enter in it in a way that the person then can't pursue their legal rights under the law. However, I think that what we're dealing with is a little, this is a difficult thing to get at because there's another public good that we're seeking to resolve, which is we do want to stop that kind of behavior in the workplace. And it might require that illegal activity that you can no longer enter into an agreement, a non-disclosure agreement, that would prevent the public or for individuals to know about that illegal activity in the workplace. And that's what gets a little dicey because clearly, I think we agree, we don't want this to go on. We don't want this behavior to exist in our workplaces. But we're both trying to figure out a way that we can write a law that makes it clear that that activity is no longer protected, that non-disclosure agreements, non-disparagement agreements are no longer protect that kind of activity in a workplace. And I think that's what's difficult. We're trying to get at it in this piece of legislation. And I think we are open to continued conversation if there's a better way to draft it. But ultimately, we may not agree on how important, we might not be able to find an agreement that will allow us to move forward because we may have different goals. We may approach this a little bit differently.
Thank you very much. Madam Chairman, I appreciate the dialogue and the comments that you're making. I just struggle because I'm not operating off of what you're saying. I'm operating off what the bill says. And those are not exactly the same things. You're referring to whether or not criminal activity is being barred from being included in an NDA, but the bill doesn't say that. The bill talks about what the employee reasonably believes to be impermissible behavior, and then it describes some things that could be criminal behavior. But what if an employee steals from their employer? The employer catches them, and then they try and, in an effort to prevent that from being disclosed because the employee doesn't want to have their reputation tarnished when they go into the world to look for another job, they agree to, give back the money and maybe some other, benefit or something that the employee had or employer had provided them. This bill prevents that. Based on your comments, let alone the bill, that's criminal behavior. Guess what? Now the criminal behavior is now something that we can't hide. And therefore, even though the employer doesn't want to prosecute, the employee doesn't want to be prosecuted, guess what? They're going to have to. And it's all is a direct result of the desire that this legislation is very clear on to deny the freedom to make those choices individually. And again, as I said, on the coercion issue, if we were going to write a bill specific to prohibiting coercion and creating a very significant penalty for an employer that coerced an employee into signing an NDA, then I'm with you 100%. Let's do it. But that's not what this is. This is all about prohibiting parties from entering into NDAs. And I get the goal of the committee's leadership and the proponents of this bill is not about harming employees. I'm just saying that is a direct consequence of the language that you have. And I tried to fix it. If you don't want to fix it, that's up to you. But note that I'm not going to vote for a bill that actually harms the employee. The NDAs often help the victim in a case when they are the victim. I just described a case where the employer's the victim. But in a case that you guys are focused on, where the employee is the victim, sometimes the employee benefits from the NDA. You know, they don't want the public attention. They want privacy. They want a faster resolution. They don't want to have things tied up in court for a long period of time. They might want to move on from this set of circumstances. In my view, that trumps everything. Their freedom to decide that is what matters. And that's why the amendment that I had drafted, again, I don't mean to keep hashing over an amendment we've already offered and failed, but the purpose of that was to make it as simple, cut and dry as possible. The employees should have the right to decide for themselves, and notwithstanding everything else in the bill, let's keep that right. And that's why I did it that way, because I thought I could make it as clear, black and white for you guys as possible to say, yeah, you're right. You know what? No matter whatever else we agree on, they should still have that right. I don't know that even fixes the bill entirely. I think the bill has a lot of other problems. You know, I mentioned the reasonably believes language, even legally impermissible. That's other, lawyer, language that makes lawyers rich, basically, because it's not objective enough to make a clear standard. The penalties that are in here, the empowering of CHRO, I think there's a chilling effect on business, as I mentioned. So again, I would support the bill under if the amendment had passed. I would have gladly done that, and I'm telling you that for the record, so that as we move forward, you understand fully that that's the make or break deal for me. Preserving the employee's right to decide whether they want to enter into the agreement or not. To me, that's what matters more than anything else. And I'm really upset that I can't support a bill that I know does help people in some ways, but it also has the potential to harm others in very significant ways too. And I feel terrible because people came to us and asked us for help, and I think we have the ability to give it to them, but we've got to do it right. We can't do it in a way that creates other unintended consequences. So I'll be a no today, Madam Chairman. Thank you.
Thank you. And I do appreciate the discussion we've had here today. And, I hope that we can continue working on it, because it would be, I think it would be incredible if we could pass something that we agree on, would help protect those people that we've heard from, because their stories were very compelling.
I agree.
Representative Hughes.
Thank you, Madam Chair. I just wanted to level set a little bit about some of the discussion that we've had around a lot of virtually no employee goes into a work setting and says, well, in case I get assaulted at work, I should probably have a lawyer look at this NDA that I'm expected to sign upon a job offer. I think that nobody goes into a workplace thinking that some of the most egregious criminal and life-destroying behaviors are going to happen to them. So I respect the idea that this is an individual choice, but when we're talking about something that prospectively we have no idea what the risks are, I think that is a little presumptive, because some of these behaviors have been going on for years in some of these biggest employers. So, and that is because there has been no accountability and because the employee has the least power. So I think that this bill is trying to really open up a window on what a lot of survivors have had to carry with them in silence. I would like to also say there is no financial compensation that makes people whole after some of the abuse that they've encountered in these workplaces. There is no financial benefit that can even begin to address that. Third, that no victim survivor wants to be in front of a court. So the idea that this is a boon for litigator, you ask any of our survivors if they reported this criminal behavior to police, and 9 out of 10 will say no. And that's because the system is rigged to just blame and further traumatize survivors rather than support them. That's the way our system defaults to, and every survivor knows that. So as we try to look at the actual experience of what is reasonable, I think we have to take into account the systematic, casual, complicit systems of abuse that have been allowed to thrive in silence and been protected through these NDAs. And that is why we are being very specific that they're unenforceable, to give survivors and their counterparts that come after them an expectation that this will no longer be not only tolerated, but expected, that everyone will be silenced by perpetrators that are allowed to advance, and employees that often try to leave for their own mental health and survival benefit, but they cannot pursue justice. And quite frankly, they will never be whole again. And I think that the amount of harm that is done to these workers is why we have to be so prospective about about legislation to protect them. And I think this does that. I also think it's reasonable to make sure that employees have an understanding of what that choice is, and to maybe narrowly craft language that still allows them to enter into an agreement excluding the criminal behavior, and to protect both parties. But I also would recommend that person really review that with a lawyer, which a lot of employees may not have access to. Thank you, Madam Chair.
Thank you. Any other comments, or Representative Weir?
Thank you, Madam Chair, and my colleague. I listened to Representative Hughes down the table, and also the thoughtful comments from Senator Sampson. Madam Chair, we've heard about obviously wanting to give the victim the choice, or the proposed victim the choice to enter into that agreement, and we don't want to take that choice away. But as this, if all these agreements are null and void, where does this ultimately get adjudicated? If the proposed victim doesn't have the opportunity to move on, to be perhaps compensated, or to enter into one of these agreements and have it they may be the one who wants to have it enforced. What other recourse do they have? What's the next step if these are voided?
So I don't know if I'm going to be answering your question, but I do think in this legislation we distinguish between agreements that were signed at the outset of employment or during employment. We distinguish that from agreements that were signed on separation. And I think that what we're seeking to do on the separation agreements, which I think is where we're having the most discussion, I think that what we're seeking to do is to make sure that if an individual who signed a non-disclosure agreement separates from the company, signed on separation, that then they tell someone what happened. And then they get sued by that employer for breaking the non-disclosure agreement. that they would have the ability to defend their position, prove in a court that that non-disclosure agreement was prohibited and now void, they would only be able to recover their legal costs. So what we're doing in this bill is giving someone who has a belief that the agreement that they signed was a prohibited agreement, that it should have been voided. Now they're being sued by their employer for disclosing what happened. In that case, they would be able to recover attorney's fees. And I think that's a distinction. I mean, it's not something we have talked about, but I think that distinction is important to note.
And thank you for that explanation. And I guess where I'm going with this, and you didn't say this, I'm going to respond to Representative Hughes if I may, but that part of the concern with the victim is having to report this and go to the police or have this end up in a court setting. But this bill doesn't do that. This takes away the ability to keep it private, and the only way that they're going to be compensated is by coming forward and making this a potentially public. That's the way I read it. That is the argument that I heard. I'm not trying to, I want to make sure that we get this right, because if this goes out of the building like this and we're wrong, that's going to be the victim's only opportunity is to report it to the police, which they already have to do. None of this, you talk about sexual assault, physical assault, embezzlement, these, excuse me, I want to make sure legally impermissible is another word for illegal. And these are illegal activities which are not permitted by law. So these are not, none of those would be covered under a non-disclosure agreement for an employee coming forward and looking to seek those out criminally. That's what whistleblower protections are for. And I don't believe that any NDA today that exists would be, if an employee came forward with a whistleblower type allegation, they're protected even when they're under the terms of an NDA. So I want to make sure that, to Senator Sampson's point, I think to everybody on this at this table wants to make sure that whatever comes out of this legislation, that we don't force the claimed victim to now have to make it a public spectacle in order to seek redress.
Thank you. Seeing no other hands, I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 2, Senate Bill 355, an act concerning limitations on the use of non-disclosure agreements. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson.
Sampson's no.
Representative Weir.
No.
Representative Hall. Representative Hall, if you can unmute yourself.
Representative Hall, we're seeing your feet. Oh, there you are.
Representative Hall says yes.
Thank you. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Canino.
No.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you, and the votes will be held open. Moving on to item number, if I find my agenda, I believe it's item number 3. Here, I crossed them off.